Hello, everyone, and welcome to Mayor Brown's webinar on managing contract risk with suppliers and distributors. We're absolutely delighted to have you all with us today. Next slide. My name is Brad Peterson, and I am a partner in Mayor Brown's Chicago office. I lead our technology transactions practice, which focuses on the supply chain for services, data, and technology, and I'm a co-leader of our firm's supply chain and distribution practice. Joining me today are two of my partners, Michelle Gross, a partner in our Palo Alto office, and Miles Robinson, a partner in our London office. Michelle has extensive experience in supply chain relationships and focuses on IP transactions, and Miles is an experienced commercial litigator who, for over 20 years, has been the first person that I call when a client has a supply chain dispute in Europe. Before we begin, I have three housekeeping comments. First, if you're accessing Mayor Brown webinars via this WebEx platform, we suggest, if at all possible, dialing in directly instead of through another service like Citrix for better sound quality. Second, if you have questions, please submit them via the chat feature, which is on the right side of your screen. We do our absolute best to address all questions live, and if not, we will work to get to you after today's program. And third and final, for CLE credit, if you're applying for CLE credit, we will provide an alphanumeric code during the presentation, once in the middle and once at the end. In order to receive CLE credit, you must record this code on the virtual sign-in sheet and return it to us, and we'll give you instructions on where to return it to us when we give you the alphanumeric code. With that said, let's get started. In 2020, supply chains truly made news. We had a massive supply chain disruption from the pandemic, which was added on top of the supply chain disruptions already caused by global trade tensions, which were added on top of those caused by cyber attacks and digital transformation. And supply chain issues have become not only front page news, but they become a topic of discussion among global leaders and C-suite executives. Now, for many of you, that's not a surprise. It's probably a long overdue recognition of the increasing reliance of the world economy on supply chains, not just in goods, but in services, technology, and data. The point, though, and the reason that we're having this webinar today is supply chain has gone from a back office function to a critical source of competitive advantage. On the next slide, we see a quote from August report by the McKinsey Global Institute. And McKinsey notes that in the past 20 years, the success of these intricate, complex production models has tripled global trade in intermediate goods. And I think we've seen the same or more in services and substantially more in areas like data. McKinsey predicts that companies will face major supply chain disruptions every 3.7 years. So, with rising volumes, rising complexity, and rising disruptions, we've got key risks that will require concerted work by everyone at your companies: business, technical, operational, supply chain, and other specialties. And the events of 2020 have shown this to be a shared global challenge involving not just contracting companies, but the governments that regulate them and the standard-setting organizations and so forth that align industries. Now, of course, supply chain and distribution lawyers have an absolutely vital role to play. On the next slide, you'll see a list of areas that our supply chain and distribution practice is focused on helping. Today, we as supply chain lawyers are called upon to go beyond helping clients to execute proven strategies for the predictable world that we had until these recent shocks, to being strategic advisors, collaborating with our clients to address novel issues. So, for example, if you faced a supply chain shock here and you're thinking of beginning a strategy of dual sourcing or reducing geographic concentration, you might need to build new contractual relationships, address the financial challenge of the new suppliers face, including through supply chain finance efforts, manage disputes with your existing suppliers, and prepare for future supply chain disruptions. You may face critical legal and compliance issues, including customs, tariffs, and trade regulations. You may face compliance and reputational risk. You may look for tax efficiency, maintenance of IP rights, and dealing with IP risks, and complying with antitrust and competition laws with your distributors. And you likely are investing in AI platforms, online intermediaries, and other technology to make all that possible. So with that introduction, let's talk about our topics for today. We're covering 3 topics today. First, the overall topic is how to manage contract risk. And by contract risk, we mean the risk of failure of supply chain contracts to work in changing circumstances. So we'll take 3 approaches to that. I will focus on establishing high-value contracts for critical services and goods and data and technology. Then Michelle will talk about how to leverage intellectual property laws and collaborations to create stronger bonds between companies. And Miles will focus on how to manage disputes to achieve favorable outcomes while hopefully improving relationships with suppliers, but at very least minimizing the damage. Throughout this program, we are all focused on making supply chain relationships better, more flexible, more collaborative, more agile, more innovative, and more resilient. So with that, let's go to topic number 1, establishing high-value contracts. And to begin that, let's quickly review what the key supply chain value drivers are. Those include, of course, on-time delivery of the right quantities of the specified quantities at the anticipated cost. That's the core of the deal. But in addition, because supply chain is a determinant of competitive advantage, in our increasingly competitive world, we see our clients relying on their suppliers and distributors to bring market-leading innovations, to meet regulatory, legal, and market expectations, and help companies face not just compliance risk, reputational risk, to supply despite force majeure events and other difficulties, to maintain collaborative, agile, and productive relationships. There are many contract provisions that can help mitigate the risk to these critical value drivers. And on the next slide, I've listed the core tools that companies use with their suppliers and distributors to mitigate these risks. The simple view, of course, and what we all learn in law school, is that contracts establish long-term commitments. And long-term commitments reduce the risk of spot market pricing and over and under delivery and the inability to get product when you need it, as we found in the pandemic. More sophisticated supply chain contracts are focused on creating options. Options manage the risk of unexpected events. And the value of the options can be estimated based on the expected benefit that the option will provide if it's exercised and how likely it is that it will be exercised. So, going to a pandemic example, a right to use a backup facility might be worth $1 million. And it might be that based on the McKinsey report and others, you see a 1 in 10 chance of actually needing the backup facility. Well, having a backup facility as a committed option, as a real option, is then worth 10% of $1 million or 100,000. Similarly, supply chain contracts that allow you to increase and decrease your buy have been vital here in the pandemic as expectations have been completely unwound as to what quantities will be purchased. And then there are contractual incentives. Companies use those to link payment to performance. Some of them are simple and automatic, such as performance credits and sales bonuses. Others require you to get miles into the room. They include things like indemnities and rights to damages. And often we just think about the ways that the commitments, options, and incentives will help, because those are, at least in theory, enforceable in court. However, the most effective supply chain companies, the people on the leading edge, the ones that have been driving their business through supply chain contracts also look at provisions which are not legally enforceable. And I'll highlight here what we'll call alignment and understanding provisions. The alignment provisions include obligations to keep key personnel in defined roles and to have meetings and reports and governance meetings and so forth. And in the pandemic, when we were watching and working with our clients to scramble to solve problems, the ones with the best alignment provisions, the ones who had built for the ability to have difficult conversations, were able to get in the front of the line and solve their problems the most quickly. And then in addition, there is understanding within a contract, provisions that, for example, require annual financial statements to understand the supplier's financial resilience, copies of the disaster recovery plan, the data security plans, and so forth. And commitments, options, incentives, and alignment and understanding are all present in legal contracts, but as we're spending more time with contracts, the way contracts are managed on the ground, we're seeing that they're also present in other contracting vehicles. And on the next slide, we show 3 supply chain contracting methods that we believe are prominent for complex contracts at all of our clients. So we as lawyers are working probably with procurement and marketing teams to create legally enforceable contracts with monetary remedies, and we work to enforce those with legal notices. But those often are incomplete. They don't say enough about what the parties will do. So often we have 2 other forms of contracts. In fact, it's maybe generally. One are what Lisa Bernstein at University of Chicago Law School has coined as managerial contracts or managerial provisions. And those are built by technical operation and compliance teams and are there to improve consistency, efficiency, integration, compliance, and so forth with detailed policies, standards, and requirements. Often, these dwarf our legal contracts in terms of not only depth, but length. On a third path, we also have relational contracts. And we all know that there's someone running most of the supply chain relationships, but they also are building relational contracts, as all of us who have worked in this area know. And the reason that economists call these relational contracts is that they rely directly on the relationships between the individuals, and the economists draw on game theory in analyzing how they operate. We need to recognize that all 3 of these are ways that you can use commitments, options, incentives, and alignment and understanding to generate value. So what would I recommend that you do at this point? At a high level, it's not easy to simply pivot when you recognize that there's a substantial new risk, like the supply chain risk. It's difficult, particularly here, because the supply chain issues cut across functional silos. And there's a great lack of understanding of how supply chains actually work, and it will require investment of both time and resources at every level to do better at supply chain. So if you're thinking about a project to do better at supply chain, we'd recommend a 3-step project. Step 1, assess your current contracting. Step 2, plan the contracting approach. And step 3, implement, execute by contracting to manage risk. On the next slide, actually, I think I didn't call for the next slide early enough, but on the next slide, we've got some ideas on how to do step 1, assessing the current contracting. The first step is to understand the full supply chain, which the term means is starting from the ground and getting to the consumer. And each entity in the supply chain is a part of many interacting systems. And what you do in contracts will, of course, affect the subcontractors of the other party, and it has effects all the way down to the consumer. And all of this is relevant to designing a great supply chain contract. Also, you need to align with the other teams. As we've said, a large-scale deal crosses internal boundaries, so there are lots of stakeholders, and understanding what each of those is interested in, business, operational, technical, procurement, and so forth, will help to design a great contract. getting to know who is leading for each role is essential in coming up with um, a great assessment of your current place. Then align on what drives value. We've given some of those standard ideas, but corporate strategy defines what defines value. The value in a supply chain is based on how it develops competitive advantage. So to maximize value and manage risk, you need to be aligned on what are the value drivers. And then finally, understand how contracts are documented and modified in practice. Again and again, I've been surprised, and our clients have been surprised by realizing what's actually happening with the legal contracts we've written. So understand what is happening today. Are your contracts fit for purpose? We often see contracts that were written when a relationship was small still be there unchanged when the relationship has grown or morphed considerably, so they're not applicable. Are the legal, managerial, relational contracts working together? In some cases, we see clients with tremendously effective systems where all three are working together and each supports the other. In other cases, we've seen, and probably more frequently because we're lawyers and we see more problems than successes, we see them working against each other. And then finally, what is the user experience for the supply chain contracts that you have? The key to success here is to make sure that the people who are actually managing the contracts, probably the people at the relationship face, can truly use the contracts to find the contract rights they have and deploy them effectively. So with that background, let's move on to the next slide on planning. Next step is plan. Got a few ideas here. One is seek a budget. This is a great moment to be seeking a budget to improve supply chain contracting because supply chain has the attention of the C-level. And supply chain contracting has tremendous ROI. If you think about it, a company that improves the value of $1 billion by 5% returns $50 million for that, far less than the cost of anything we would propose here. Even a 1% chain improvement returns $10 million, a spectacular return on what it would take to dramatically improve contracting. Second, reduce the risk of conflicts between the various people. Different people with different agendas will often push in different directions, and we often see problems when people on the relationship or managerial contracts actually override contractual protections imposed for very good reasons. And I'm sure that the people in the other tracks find themselves frustrated with what we do. Third, give some serious thought to your standard provisions. Often the companies we work with have templates that they've been using for years. I was talking to we had a group of us speaking with one of our leading clients about supply chain issues, and the client lead on supply chain says, the difference now post-pandemic is there is no playbook now. And there's so much new. And I want to pick on the example of force majeure, for example, which is a boilerplate clause that works beautifully if you assume that the customer is dual sourcing, and as a result, the customer is not relying on the supplier to have, for example, 2 facilities. But it's a terrible idea to excuse a supplier from performance if it's your sole source of supply, and if you could actually ask the supplier to have 2 manufacturing facilities, for example. These decisions need to be made not as boilerplate or playbook, but based on the deal as it stands. Finally, again, designed for the users. Too often we see the contracts being designed not for the users who will use them, but designed for a court that will never see them. And supply chain contracts are often managed by supply chain management professionals with no legal training, and writing for that audience is tremendously helpful. So think about how you can do that with your contracts. That takes us to the third piece, contract to manage risk. A few points here. First, we often as lawyers, it's easiest and most straightforward and seems the top of mind to focus on reps, warranties, indemnities, limitations of liabilities, and so forth. Those are very important. The real focus is on the core of the business deal, what you could think of as the 5 Ps. What product is being purchased and sold? What performance is required in terms of functionality, quality, timeliness, efficiency, compliance, availability, and so forth? What price will the buyer pay? To what place will the products be delivered? And what powers, what options can the parties exercise under the contract? Those business terms should be driving the choices on legal terms, not what was in a template that was written many years ago for a different deal. A second, design contract governance for strong, well-networked, well-supported teams on both sides. That's essential, particularly in the pandemic. We've seen the value of having those relationships. Third, make sure that the right contract mechanism is being applied for each of the risks. It might be legal contracting, might be managerial contracting, might be relationship contracting. Each is valuable. Relational contracting is very agile and very quick. Managerial allows tremendous amounts of detail. Legal contracts have enforceability. So there's benefit in all three, but it's best to use each one appropriately. And to draft the formal legal contract to support what's going on the managerial contracting side and the relational side. And then finally, again, make the entire agreement communicate and be an effective tool for the users. The entire collection of documents should be reviewed. We as lawyers cannot do our best in the silo. We must do our best by understanding the entire supply chain, the entire deal, and creating a great contract that mitigates and manages the risks. And with those steps, you'll have better contracts, better relationships, and less risk. Now I'd like to turn the microphone over to Michelle Gross to talk about how to leverage IP laws and collaborations to create stronger bonds.
Thanks, Brad. One of the trends that we're seeing in engagements with suppliers and distributors involves increased collaborations between the parties. Companies are increasingly relying on suppliers and distributors for critical innovation. Sometimes this is because the supplier or distributor has critical know-how that can be augmented with the collaboration. Collaborative contracts allow the parties to leverage their joint insights and capabilities to address supply chain shocks and mitigate other risks. There are various contract structures that can be used to formalize these arrangements, such as a strategic alliance with distributors, joint development agreement with their suppliers, or the parties may choose to form a joint venture to govern the relationship. Next slide, please. The first question you're going to want to ask is, does the collaboration make sense? Collaborations often take a significant amount of structural consideration as well as time drafting and negotiating key terms. You want to be sure that the proposed collaboration is the right business solution. Typically, a collaboration occurs when greater commercial value can be generated collectively than either of the two organizations can achieve independently. Successful collaborations tend to occur in connection with either market expansion, investment affordability, or risk sharing. Market expansion refers to capturing new market opportunities, for example, geographic expansion, new distribution channels, new product development. And investment affordability refers to situations where investment funds are pooled to create value that each party could not afford independently. The collaboration usually does involve an agreement, some kind of agreement to share resources such as goodwill, expertise, capital, to increase the performance of the parties. And the collaboration itself can be for a specific project or time period, or it can be relational, meaning that it's ongoing until terminated. Whether the collaboration driver is market expansion or investment affordability, the protection of intellectual property assets is critical because each party will likely have an interest in using those assets both during and after the collaboration. So I'll quickly note that a collaboration does not necessarily involve the formation of a new legal entity. In fact, I would say it often does not. Nevertheless, even when a new legal entity is not formed, collaborations often involve complex IP issues, and that's what we're going to touch on next. Next slide, please. Okay, so before we get into things to consider before contributing IP, let's quickly go over the difference between background IP and foreground IP. Of course, these terms are going to have the definitions assigned to them in a contract, but at the term sheet stage, which is a critical stage for setting the groundwork, typically background IP refers to IP that is made available to the collaborating party during the term of the contract. And it often includes IP created before the collaboration, IP created during the collaboration, but separately and independently of the collaboration, and IP created after the date of the engagement and made available to the collaborating parties for the purpose of undertaking the project. And then foreground IP refers to IP created by a party in connection with the project. So that's the core IP that has been created. Before you contribute IP to a collaboration, it's important to understand how existing IP assets will be shared. Parties will often default to simple cross-licenses. Each party gets to use the other's IP as needed during the engagement. But oftentimes, the licenses should be distinct individual licenses carefully tailored to reflect each party's actual use. Next, you're going to want to agree on the value of the contributed IP assets. And this is relevant where a new legal entity is formed, of course, but also more generally as the parties begin to understand what each party is bringing to the table. Regardless of value, all background IP should remain the property of the contributing party, and any licenses to background IP should be narrowly tailored, keeping in mind the geographic scope of the license, the duration of the license, defining the right licensee parties, whether those rights should be transferable and for what purpose, and careful definition around the use right itself. For long-term engagements, we often suggest a built-in IP review process to assess and adjust the parties' respective responsibilities and royalties so that successful business collaboration can be maintained. Keep in mind that collaborations and JVs often operate like startups, incorporating similar uncertainties and risks. Parties often come together to collaborate toward solving a new problem or improving a process in a way that's never been done before. So this means there are inherent uncertainties and risks built into the collaboration. And that is often a consideration when determining the term of the collaboration and what exit options should be built into the contract. Similarly, when you think about what post-transaction IP rights each party will have, you'll want to consider these rights in the context of a cordial termination as well as a contentious termination. Next slide, please. Okay, let's move on to some of the key IP considerations when drafting and negotiating IP terms in a collaboration. Parties often start with the allocation of responsibility for developing new IP rights. It's important to carefully allocate responsibility for any development work, not just for performance purposes, performance measurement purposes, for example, but also because that allocation of responsibility tends to drive discussions around the scope of the rights to be licensed. You'll want to think about use rights during any development stage as well as throughout the term of the collaboration, and then any post-termination rights. They may be and often are very distinct. The rights granted may be limited by field of use or a defined territory, or they may be limited by the market for use of the licensed IP. It's also important to address whether each party will be allowed to exploit the newly developed IP outside the scope of the collaboration. Sometimes the licensee is prohibited from using the developed IP outside the collaboration, while other times the licensee will have limited use rights. When you do have broad rights that are granted, it's not unusual to see them scaled back or nullified if the underlying agreement is terminated because of a breach of the licensee. Another topic you'll want to address is sublicensing. Will sublicensing be allowed, and if so, pursuant to what terms? You want to consider what rights distributors and contract manufacturers may need. Similarly, the licensor may need to maintain certain rights, such as the right to monitor use of any trademark so that the goodwill of the mark is preserved. You should also specify who will monitor any potential infringement by third parties and what reporting responsibilities each party will have in the event that they do become aware of an infringement. Similarly, you'll need to address who will handle the defense of any third-party infringement claims, how any related costs will be handled, how any awards will be distributed. And then from an administrative perspective, the contract should also address who will pay for registration and maintenance. And it's also important to address as many of these points as possible, because if a dispute does arise, it's not always predictable how a court or an arbitrator will resolve the dispute. Next slide, please. One case that comes to mind that's relevant to this point is the 2017 CONTRACTIN case, which involves a trademark dispute. So CONTRACTIN is a company that manufactures packaging and reflective insulation. They entered into an agreement with TVM Building Products that designated TVM as the exclusive marketer and distributor of certain products in the U.S., and those products were distributed using an unregistered mark. After the agreement was terminated, TVM continued to market the product using the Ultra mark, the unregistered mark, and CONTRACTIN ultimately sued TVM. The trial court ruled for CONTRACTIN on its trademark claims, and of course, TVM appealed. In assessing ownership of the mark, the trial court relied on the first use test, a fairly common test, which determines ownership by asking which party was the first to use an unregistered trademark in commerce. The appeals court acknowledged that the first use test is generally considered the appropriate test for unregistered trademarks, but found that the manufacturer-distributor relationship is so unique that a different standard should be used. And they noted the exclusive and non-competitive nature of the manufacturer-distributor relationship. The court noted that if the first use test were to be applied, ownership rights would go to the distributor in many cases simply because the distributor made the initial sale of goods bearing the mark to the public. That's their role. Thus, the court said a different test is necessary when ownership isn't otherwise agreed to by the parties in the contract, which was the case here. So on appeal, the court held that the so-called McCarthy test should be applied, and under that test, the manufacturer is the presumptive trademark owner. However, the distributor can rebut that presumption using a balancing test with their 6 factors. So I won't walk through those 6 factors here, but this approach generally allows for a more thorough individualized analysis of each case that accounts for the unique attributes of the manufacturer-distributor relationship. And then, if you apply the test to the CONTRACTIN TVM relationship, the court found that by balancing the 6 factors, they weighed in favor of CONTRACTIN. So there was a bit of trademark detail in this case, but the broader point here is that when possible, collaborators should try to address IP issues in the agreement rather than leaving the decision to a court. You never know when a court will decide to apply a new test, as they did here. Next slide, please. Sometimes in collaborative arrangements, it's difficult to clearly delineate ownership rights. So when that happens, we as lawyers often find ourselves working through joint ownership arrangements. Joint ownership is often a preferred approach for collaborating parties because it allows the parties to potentially avoid uncomfortable conversations about which party should own the newly developed IP. So instead of one party owning, you can collaboratively agree that the intellectual property will be jointly owned. Many of you have probably heard the warning that joint ownership of IP can be challenging and can have unintended consequences. For example, a joint owner of a patent may assign its whole interest without the need to obtain the consent of the other joint owners. But a joint owner may not license the patent without the consent of all the other joint owners. Joint ownership also raises challenging issues when it comes to prosecuting, registering, maintaining, and enforcing jointly owned IP. For example, what happens if one party wants to prosecute a patent in a jurisdiction where the other joint owner does not want to and prefers to maintain the IP as a trade secret? or if a joint owner wants to sue a third party for infringement, but the rules of the jurisdiction require that all joint owners be joined as parties to the infringement claim. To avoid some of these complications, parties should try to clearly define the ownership of contributed IP and joint IP, including post-termination rights, a theme in my talk here. Clarify that the use of joint IP includes the right to use contributed IP of each party solely as embedded in or necessary to use the joint IP. You'll want to try to allocate joint IP among different fields of use or geographies if possible, and specify whether parties are obligated to account to each other for profits from use of joint IP. Lastly, you'll want to try to allocate to the contributing party the IP it created in the course of collaboration that is ancillary to or separate from the central purpose of the collaboration and is derivative of its contributed IP. Next slide, please. The issue of joint ownership becomes even more complicated when the same jointly owned asset is protected in multiple jurisdictions. That's often the case with patents and trademarks. Because different countries often have different rules governing joint ownership, the joint owners may not be fully aware of the implications of joint ownership in a particular jurisdiction. Default IP laws vary depending on the type of IP. So where a foreign party is involved, a meeting of the minds is critical as to what the party's expectations are with respect to joint ownership of IP rights involved. Because IP law is territorial, and by that I mean that countries enact their own IP laws and these IP laws have no application or force outside the applicable country, management of jointly owned IP can be made a little bit more clear where the ownership rights of each party are allocated among different fields of use or different territories. But without agreements between the parties, courts look to default laws to determine what constitutes joint IP and each party's rights related to that IP. So if you're involved in a collaboration that could include a patent filing in multiple jurisdictions, we highly recommend consulting with an IP attorney to ensure your agreement contains express rules and processes for managing that IP. Otherwise, the default rules will apply, and they may or may not work for your particular jurisdiction. I'll conclude by providing a quick overview of the difference in the default rules in China and the US. This is just an example. The PRC patent law was amended for the third time in 2008, and the amendment specifically addressed joint ownership of patents. So as of that effective date, a joint owner in China is entitled to exploit the jointly owned patent alone or grant a non-exclusive license to a third party to exploit the patent. But any fees generated from that license must be shared among all joint owners. This royalty sharing requirement is different from the US approach, where royalty sharing is not required. Also, unlike the US default rules, in China, courts generally allow each joint owner to enforce without the consent of others. Now, please keep in mind that these are just some of the differences in the rules of joint ownership with respect to patents in the US and China. There are also differences in other jurisdictions and with respect to other types of IP, such as copyright and trade secrets. So with that, I'll hand it over to my colleague, Miles Robinson, to discuss managing disputes to achieve favorable outcomes.
Thanks very much, Michelle, and thanks, Brad, as well. If you could move to the next slide, please. So disputes within supply chains have formed part of my practice for over 20 years. As the complexity of these supply chains have increased, the more these disputes have become business critical. COVID has proved to be a huge stress test for supply chains, but not one that is out of keeping with the general trend that we see. Brad's quote from McKinsey earlier in the presentation is highly relevant. If companies can now expect supply chain disruptions lasting a month or longer to occur every 3.7 years, that is likely to generate a material number of disputes. So this is an area that merits attention, both to understand what types of disputes to expect and the options for handling them. So today I'm going to cover first where we see most disputes arising, then look at your dispute resolution options and approaches, and I'll finish with some practical tips on handling these disputes. And I think although I am an English lawyer and so I'm influenced by what I see in this jurisdiction, the themes that we cover tend to be common across the jurisdictions, I would say. Next slide, please. So what is it about modern supply chains that make them susceptible to disputes? I've listed some factors that I think contribute to this. Obviously, I'm making some generalizations here, but at a very high level, the more parties and interconnected moving parts that are involved, the more likely it is that something will go wrong. In my experience, and certainly we've seen this over the past few months, businesses that have built in resilience to supply chains, such as multi-source arrangements, have been much better able to weather the recent storms. So looking at the slide, the factors that I've listed illustrate the tension between cost and complexity. You have cost savings being achieved by looking at sourcing from lower cost locations, which in turn brings into play more parties, more jurisdictions, and longer contractual chains, and so more risk. Similarly, where you have just-in-time logistics, it certainly can lower cost and lower the requirement for working capital, but conversely, just-in-time logistics increase the risk if something goes wrong. Next slide, please. So moving on to some common areas where we see disputes arising. This is not by any means intended to be a comprehensive list, but hopefully it gives a flavour of what we generally have seen in practice over the years, and particularly over the last few months. And I think as Brad mentioned, we see supply chain as quite a broad area, certainly covering both physical goods supply and also related contracts dealing with the supply of technology and technology services, which are often critical to the operation of the physical supply chain. Now, while on the subject of technology contracts, there are some aspects of disputes arising from those contracts that tend to be different from those involving the physical supply chain, not least because technology contracts often involve a high level of collaboration and interaction between the parties, and therefore more complex governance and dispute resolution provisions. However, at a high level, the overall themes are similar in both technology and physical goods supply chain disputes, in our view. So I've started with some themes that tend to apply more to technology disputes, although, as I said, certainly not exclusively so. First point I've mentioned relates to the equality of the bargain. Achieving a great deal on price, scope, or implementation timescale might be beneficial in the short term, but this can store up significant problems in the future. If a deal is too marginal, it can very easily slip into a negative situation where either party is needing to cut corners or be aggressive in their interpretation of responsibilities. This almost inevitably leads to disputes and, more broadly, a relationship where incentives are not aligned. Similarly, when a deal is signed, all concerned often want to implement it as soon as possible. If, however, the timetable is unrealistic, that doesn't benefit either party generally. It can lead to a lack of confidence in the project from the business. It can take longer to reach the point at which anticipated savings are achieved, and just generally, it can set the project off on the wrong foot. Also, depending on how the contract is drafted, failure to hit initial milestones in the project could even lead to termination rights being exercised and the whole project being at an end. The next point on the slide is more one of expectation setting internally. The way in which a deal is sold internally can have a significant effect on its success in the long term. Inevitably, positive assumptions are made about the deal, that it will proceed smoothly, and the financial parameters often reflect this. However, if the financial projections are not met, this puts the deal under significant pressure and makes it more marginal. Care should be taken to build in some contingency for the likelihood that not everything will go smoothly. The last section on this slide is more related to contractual issues, which are all reasonably obvious, I hope. There are two that I'd like to highlight particularly. First, agreeing to negotiate details at a later stage. This is tempting and may be unavoidable in some instances, but is a very common cause of disputes and delays, particularly where there is not an effective process to resolve an inability to agree the necessary details, such as having a default position. Second point I'd like to highlight is the final one on the slide. It's tempting, particularly at the beginning of a relationship, to let minor issues go. In our experience, this can be counterproductive in that it can store up problems later and set the wrong tone for the relationship. The dispute resolution provisions in the contract are there to be used, and they can enhance rather than damage the relationship if used well. This is a theme I'll return to later in the presentation. Next slide, please. So I'll now turn to some issues that tend to be more common in physical goods-related contracts, although again, not exclusively so. I'll start with product quality issues. This can be a particularly difficult type of dispute to unpick. The more complex the product and/or the greater the number of raw materials and components that are used, the more difficult it is to identify fault, and even then, what the impact of that fault is. Generally, you'll need internal or external technical expertise to get an answer, and even then, you may have competing expert views. In terms of risk mitigation, it certainly helps to have clear specifications and requirements in place throughout the chain. But probably the most important practical thing you can do is to ensure that samples are retained for later analysis if there is a dispute. There are two angles to this. First, what you can do yourself. You can control your handling of your own samples and make sure that is done in the most appropriate way. And secondly, you can require as part of the contracting process that your counterparties retain samples properly themselves. And if they fail to do so, that will certainly put them at a disadvantage in any dispute. So I've mentioned on the slide the tension between regulatory and contractual obligations. The most obvious example is where the end product is in a regulated and/or consumer-facing market. In that scenario, those within the supply chain may be faced with the uncomfortable position of needing to instigate a notification to the authorities and/or a product recall while trying to preserve their contractual positions. Obviously, regulatory obligations have to come first, but nonetheless, clear communications and reservation of rights within the supply chain can help you navigate this difficult path. Next area I've mentioned is contractual uncertainty. It's an obvious area, but one which consistently generates disputes. The desire or commercial imperative to get started and let the formalities be addressed later is common and completely understandable, but it is a rich source of disputes. And similarly, even where the contract is concluded, key terms can be left to be sorted out later. Again, understandable, but risky. I've also mentioned on the slide the well-worn issue of the exchange of standard terms, leading to uncertainty as to whose terms apply. It may be a well-worn path, but I can tell you that it still happens, and the cross-jurisdictional nature of many transactions means that not only are important practical terms, such as timing of supply and limitation of liability, uncertain as a result, but the seemingly more esoteric questions of law and jurisdiction have a real impact if that's unclear. That can lead to costly jurisdiction battles, but more immediately, it makes it very difficult to advise the business on possible outcomes. Obviously, if you don't know which jurisdiction you're going to be fighting a dispute in, the risk and the uncertainty increases significantly. So as a practical risk mitigation tip, in our experience, clients with the most robust contract sign-off provisions and, frankly, the ability to locate historic contracts have had more limited exposure to these types of disputes, but certainly no business is immune to them. Next slide, please. On this slide, I've mentioned changing scope or price. But this is, a particularly problem where you have long-term contracts and price or supply volatility. I think this is an example where contracts that are particularly marginal can create problems. Even where you have clear provisions on pricing, a party that's being disadvantaged by unforeseen movements in the market can look for other ways to mitigate that risk, or it can even push a party into a financially unviable position in the most extreme cases. So it's important to recognise, in our view, where this might be an issue. A win at the beginning on pricing may not be a win in the long term, and a more balanced contract may create a more stable position, particularly for single source or critical raw materials. This is where businesses benefit from viewing its supply chain holistically rather than operating in isolation, and making sure that attention is paid to stability of supply as opposed to price alone. Next, I've given some examples of situations where parties may be forced into a situation where they're unable to supply. COVID is the obvious and most recent example, but this is certainly not a new issue. All of these sorts of events have put a greater than ever focus on the resilience of supply chains and the risk allocation provisions in contracts. Certainly, it's a particular issue for parties in the middle of the supply chain, who can be in the unfortunate position of having to argue to their supplier that supplier should be able to continue to supply, while trying to argue with their customer that they should be entitled to rely on the contractual protections available to them. So liability provisions here are critical. Obviously, what can you pass on? What are your protections? Brad mentioned the spotlight that's been thrown on force majeure clauses. I certainly agree with him that I don't think these will ever be considered boilerplate clauses in future, and I expect them to be quite heavily negotiated. Next slide, please. So on this slide, I've listed a number of options to consider when drafting dispute resolution clauses. As with force majeure clauses, every contract's different. What's suitable for one contract may not be suitable for another. So where you can, I'd urge you to give these sort of dispute resolution provisions careful thought rather than treating them as boilerplate. So second key point here is to consider whether it's worth including an issue-specific dispute resolution mechanism, such as one for payment disputes or for technical issues, or even a rough and ready mechanism to resolve smaller disputes, just to get them out of the way quickly. It can be a very, very effective way of carving out things that you're particularly concerned about and having them dealt with in the most appropriate way. So each of the methods listed have their benefits and downsides, and it's outside the scope of this talk to go through them all. But also in terms of approach, bear in mind that many of these can be used in parallel, both with each other and also with more informal methods. And I'll touch on this shortly. Next slide, please. So how do you approach these disputes when they arise? You've heard this already in the presentation, but there's no playbook here. There are some fundamentals involved when advising on these types of disputes, similar to advising on many other types of disputes. Namely, that you need to understand the facts and the legal merits, you need to understand the objectives of the business, and you need to work closely with the commercial team to decide the strategy to achieve the desired result. More specifically to supply chain, it's absolutely critical to establish whether there's a plan B. This will help you decide what options might be open. For instance, it's unlikely to be realistic to threaten termination of the relationship if there are no other immediate supply options. I've talked about partnerships, making sure that commercial and legal teams work closely together. That's absolutely critical, particularly at the outset of a dispute, so the legal team really understand what the impact of the issue is and how best to go about solving it. Dispute resolution I've mentioned, quite quickly. Our view is that they're there as part of the business as usual toolkit of a business. They don't have to be seen as a declaration of war. They don't have to be seen as the start of a process which will inevitably lead to litigation or arbitration. The fact is, very few disputes even reach the stage of formal legal proceedings, let alone a final hearing. And we urge you to see these provisions and these procedures as another part of the commercial toolkit to help you achieve your commercial objectives. And also not to allow disputes to fester. That can be really toxic for a relationship generally. It can also hamper your ability to raise issues at a later stage from a legal perspective. So there are good reasons to raise disputes, but do it in the right way. Another tip from our experience is to really understand the relationships between the parties. It may be that a particular relationship on the commercial side is most likely to be the one that unlocks a resolution. How best to set that conversation up will depend on the situation, but again, parallel tracks can work well. More formal raising of issues with the informal route being kept in the background for the right time. Finally, a note of caution about complex dispute resolution provisions and governance provisions. They look great in theory, but before agreeing to them, consider whether proper resource is going to be available within the business for them to work. There's a real danger in leaving escalation provisions to senior executives who have insufficient time to devote to them. So on this final penultimate slide, some tips for handling the disputes, really areas that I've covered already. No one size fits all. Think about business continuity, but make sure you document it properly. If you're doing a quick fix, don't ignore disputes. Make sure you communicate internally and externally. Don't hamper a dispute resolution strategy by somebody within the wider team communicating something different from the messages you're trying to get across. Retain evidence and particularly samples where you need to. Use dispute resolution mechanisms and be conscious of your place within the supply chain and be as consistent as you can be up and down the supply chain if you're in the middle of it. So key points to take away from me before I get to the main key points. On dispute side, supply chain disputes will happen increasingly. They need to be handled in close partnership with the business and consider using dispute resolution provisions proactively as a commercial tool and as a way to enhance relationships. So more generally, the takeaways from the presentation as a whole, you can see them on the slide. Complex and increasingly brittle as a result of external events as we've seen. We know these shocks are going to come more regularly and have a huge impact. The opportunity is there now to provide impetus for businesses to recognise the challenges and reimagine existing supply chains with the backing of senior management. And we urge you to think about a holistic and collaborative approach. We feel that works so much better to create value and create what we see as win-win partnerships. So that concludes the prepared materials. Apologies for going slightly over time, but I'll pass over to Brad now to raise any questions that have come through during the presentation and to wrap up.
I've gotten a couple of questions about jurisdictional differences. And Miles, do you have any comments on jurisdictional differences in how disputes would most likely be handled based on your experience working on these around the globe?
Yeah, that's a great question. Quite a broad question. I mean, I think that there are definitely jurisdictional differences that really need to be factored in. A couple of key topics are how disclosure, how discovery of documents is treated, from the very broad in the US through to a very limited disclosure in countries like Germany and France. So again, that's a real consideration for where you want to have your dispute heard. Obviously there are huge differences between litigation in particular jurisdictions and arbitration. There are real benefits to arbitration, but some downsides as well. It's really a no one size fits all question, and it's really merits thinking about who your counterparties are, where you want those disputes to be heard, thinking about those jurisdictional differences or choosing a neutral jurisdiction that benefits you most. Okay, thank you very much. I think that concludes our webinar for today. Thank you everyone for joining us, and thank you Miles and Michelle for presenting. We look forward and hope that we will see you at our future supply chain and distribution or technology transactions webinars. Thank you very much.